Welcome to This Explainer. Today, we're diving into something absolutely crucial for families: Illinois parental rights in education. If you're a parent in Illinois, navigating school laws can honestly feel like you need a law degree just to check a report card. But actually, it's a lot more straightforward once you know exactly where to look. So today, we're going to demystify the law. We'll look at your baseline rights, the boundaries that shape them, and really help you build a stronger, more informed partnership with your child's school. Let's get right to it. Here's our quick roadmap. First, your core parental rights. Second, we'll cover divorce, custody, and communication. Third, privacy limits and exceptions. Fourth, special ed and support services. And finally, we'll wrap up with your practical parent toolkit. Okay, starting with Section 1, your core parental rights. So, in Illinois, your baseline rights are actually incredibly strong. But as we all know, schools and families just work a whole lot better when expectations are crystal clear. The absolutely crucial number you need to remember here is 10. One of your most vital rights is inspecting and copying your child's school records. You know, things like report cards, attendance, disciplinary files, the whole shebang. Illinois law basically says schools have to respond to your requests within a reasonable time frame. And in most cases, that literally means no later than 10 business days after they receive your request. Knowing this exact timeline is a total game changer. It ensures you aren't left waiting for months and you actually get the information you need while it's still timely and relevant. Now, when you're making these requests, you definitely don't want to just send an email into the void or hand a sticky note to a random staff member. You want to look for the official records custodian. Every single school district has to designate someone specifically for this role. They're the ones responsible for maintaining procedures and handling your requests to inspect and copy student records. So, a quick tip: check your district handbook for this exact title. Once you have it, you'll know precisely where to direct your written requests so you can get those records smoothly and efficiently. Moving right along to Section 2, divorce, custody, and communication. Now, let's talk about how these rules apply if you share parenting responsibilities or are separated. Illinois law actually pays a lot of attention to varying family dynamics to make sure kids are fully supported by all the adults in their lives. So, if you share parenting duties, standard access means the school must send reports and official notices to both parents. And here's the key: divorce alone doesn't change this. Academic progress, health notices, event calendars, those go to both households. The only exception is what's called restricted access. If there's a court order or an order of protection legally barring a parent, well, the school absolutely has to enforce that. But assuming there are no specific legal documents like that in place, both parents have a legally protected right to stay in the loop. That brings us to Section 3, privacy limits and exceptions. So we've talked about your baseline rights, and yes, they are strong, but they aren't unlimited. They're actually shaped by state and federal privacy laws. Under the Illinois School Student Records Act, your rights as a parent don't last forever. They automatically transfer directly to the student when certain life events happen. Basically, if the student turns 18, graduates from high school, gets married, or enters military service. The moment any of these occurs, whichever comes first, that legal privacy shield automatically shifts to cover the student as an independent adult. And these privacy boundaries apply to outside entities too. In situations involving formal legal processes, say warrants or subpoenas for immigration enforcement, schools have some very strict, updated rules they have to follow. If law enforcement comes looking for access to a student, schools aren't just freely handing over information. No way. They are legally mandated to require formal documentation and follow official state guidance to ensure privacy laws are completely respected. And, absolutely crucial for you to know, they are required to notify you, the parent. All right, let's shift gears to Section 4, special ed and support services. Navigating this intersection between parent authority and student confidentiality can honestly get a little complicated. It's kind of a gray area, but Illinois law specifically states that it supports parent involvement in educational planning, and that includes access to facilities, personnel, and classrooms. This is huge because it gives you a very meaningful right to be involved, especially if your child has disabilities. You're strongly encouraged to be part of the meetings and decisions that shape their support. Just keep in mind, of course, schools still need to enforce reasonable safety rules to prevent classroom disruption, so you'll just need to coordinate your visits and follow the district's standard procedures. Now, student support and specific counseling is another area that can trip folks up. For general support services, your involvement and your consent are almost always required. But, and this is a big exception, under state mental health law, there are certain specific counseling options that are legally protected by student confidentiality. That means they're allowed completely without your consent. So the practical takeaway for you here? always ask the school exactly how a specific service is classified. If you do that, you'll know exactly where you stand and exactly what notices you will or won't be getting. Okay, we've covered a lot of ground. Let's head into our final part, Section 5, your practical parent toolkit. Knowing all these laws is fantastic, right? But applying them effectively in a real world is what truly empowers you. So let's turn these baseline and boundary rules into actionable steps. Step 1. Get organized. You'll want to keep copies of custody orders, protective orders, and school communications all in one dedicated place. Step 2. Put every single record request in writing. Seriously, don't just rely on a quick passing conversation in the hallway. Step 3. Make it a habit to review your district handbook every single school year, because local policies dictate exactly how those requests should be made. And finally, Step 4. If a school ever denies you access to records or services, don't panic. Just politely ask for the reasoning in writing and request the specific law or policy they're relying on. Doing this builds a rock-solid foundation for a collaborative partnership. Just a quick reminder before we finish up. Education law is always evolving, so the information we've explored in this explainer today is really meant as a practical overview to get you started. It's not formal legal advice. If you ever hit a serious roadblock or you find yourself in a really specific dispute with your district, definitely don't hesitate to seek out official guidance. Your absolute best resources are going to be the school district itself, the Illinois State Board of Education, or a qualified attorney who really knows Illinois education law. As we wrap up this explainer, I really want you to think about this question. How will you use your rights to build a stronger partnership with your school this year? Because at the end of the day, knowing the law isn't about fighting the district. Not at all. It's about empowering yourself to be the absolute best possible advocate for your child. Clear expectations lead to better educational outcomes, for sure. So take these tools, get organized, and start collaborating. Thank you so much for joining us and learning with us today.